lawyer and a financial advisor walk into a bar.
Oh, then what happens, Dave?
Well, the question that we have from some people is, I'm not that complex.
Ah, not that complex. Yeah, just give me the one pager. That's what I get. Just the
Yeah,
one
yeah.
pager, mate. Just put
yeah.
it together on a one pager.
Yeah,
Nice
it's pretty
one.
easy, isn't it, my stuff? Just can't you just pull it together and then just tell me what I need to do?
Yeah. So do you get financial advice? Sort of clients come to you and say, "Oh, well, look, I've just got a business and a super fund, and I'm also the beneficiary of a testamentary trust, and it's all very easy." And you say, "Well, actually, it's not that easy." Is that? Yeah.
Well, yes. So the level of complexity can be, yes, I operate a business, and so I have a. Sometimes it can be a trust.
Yeah.
Sometimes it can be a company.
Yeah.
Then you realise that inside some of those structures, there are multiple directors.
Yeah.
And it might be a family trust. It could be a unit trust.
Yeah.
Or it could be a services trust. So, a whole range of different trust structures.
Yeah.
And depending on the age of the entity documentation.
Yeah.
So sometimes it can be very old.
Yeah.
And
Can
so
I just say
therefore,
on that? I had one recently that came in that was written in the 70s, a trust deed, and the client said to me, "I think Captain Cook might have written this." That was a classic. It was the party in the first part bequeaths unto the party in the second part. And I'm like, I think we better replace this bad boy because I cannot understand it.
And this is where it comes in. Oh, but I'm not that complex.
Yeah.
Yes, but the complexity comes in when multiple parties involved.
Yeah.
And so, as you said, so we have, family trust, unit trust, company, and then a company can be what the business is owned. Then it could be a corporate beneficiary of a trust. So you're distributing funds to the corporate beneficiary.
Yeah.
But you also may then have a self-managed super fund.
Yeah.
Depending on how that's structured. But you could also then be a beneficiary of a testamentary trust, so a parent's will.
Yeah.
Now, that could be combined in with siblings or a whole range of other family groups. So all of a sudden, it's like, yes, on paper it's not complex, and it's clear you can see where things go. But from a legal perspective, and who owns what, and what would happen if you were not available to deal with some of these issues because you may be the sole person inside that entity structure, then what happens if you lose capacity or become deceased yourself? Oh,
yeah,
I hadn't
and then you
thought
leave
of
it
that.
to your husband or your wife or whatever to
Correct.
Yeah, and they might not have the first clue of what's going on.
Yep.
And maybe by then your accountant's dead as well.
Correct. Correct.
Yeah.
Or there's some issue with yes, but again, I think the issue that you raised is that some of the documentation, especially the stuff that's pre-85. So if you've got a pre-CGT asset,
Yes.
how can you maintain that CGT exemption?
Yeah.
But you may want to restructure the way that you're structured.
Yeah.
So you might want to move it out of a family trust. Because the business is very successful, you may want to keep it into a company structure. So that's where the complexity also starts to come into it.
Yeah.
So your actual structures may be actually not complex.
Yeah.
But it's the succession planning that comes around it that can potentially make it very complex.
Yeah. I mean, it's complexity that's not just there to give lawyers and accountants a job, but actually to confer real benefits, real tax benefits particularly.
Correct.
But often other types of benefits on people that are that are worth hundreds of thousands of dollars, like are worth sometimes millions of dollars.
Yes.
And they're worth a little bit of complexity to get your head around is worth it because of the huge advantages. I mean, even just in a trust structure, I mean, what a trust can do for you in terms of tax savings is quite incredible. And so, although you might have a relatively small business that's run by kind of mum and dad, and you might have a few beneficiaries, the trust structure will save a lot of money in tax every year. And if it's sort of worth getting your head around a little bit of, filing a tax return for yourself and one for the trust, I mean, that's not all that much extra work, and it can save you a lot of money. So it's not just.
But it also, the classic though, on any of this, we've been running like this for years.
Yeah.
It can't be that bad.
Yeah.
But it's not until something goes wrong that then people retrospectively look back and go, oh, now I see what you mean because, right, Yeah. So what I want to be able to do, because I'm now no longer capable, I've lost capacity, or I'm deceased. We can't do some of that forward planning that might have been able to done to support, longevity and to support, a good tax planning strategy.
The people come in and they can't do anything because they're deceased.
The executive comes in and says, "Oh, can we do this?" No.
No. Yeah, you need the signature for the dead guy.
Correct.
Yeah.
Well, they don't even have a will, which is always an interesting one. So then you go to the courts to be appointed as administrator. Yeah. So I can understand why people say that a lot of the time, but I'm not that complex, because to them they've been dealing with it, day to day, and there's never been an issue. Like, it's just, it's like anything. I mean, you're always underinsured until you go to claim.
Yeah. Well, I've done some renovations recently, and it's always more complicated than you thought. It takes a bit longer, and is a bit, once the traders start explaining to you, we've pulled this wall down, and there's no, whatever's supposed to be there. I don't know. Floor. I don't know.
Yep.
And it's not the way we expected. We're going to have to grind this down and do that. So, and then the whole project gets bigger than you thought.
Correct.
So,
which is the same with any documentation.
Yeah.
Once I start reading it, and I'm sure you've said to many people, the issue that we always raise with people, read the deed.
Yeah.
What does the deed say? Your trust deed, your family trust deed. Because that sets out the rules. And if you want to amend your rules, that is possible to do that.
Yeah.
However, you need to, know where the original document is to make any adjustments to it.
Yeah.
That's always a beauty. Yeah, I'm not sure where that deed is.
Yeah.
Right, but that sets out, but I'm not that complex.
Yeah, well, you're the trustee of a trust. The trustee makes all the decisions, but we don't know what the rules are around the decision.
Correct.
Yeah, I'm with you about that. We get quite a lot of, say, how much will it you charge to do, say, an amended trust deed? And I say, may I see the trust deed, please? And they say, I don't have it. And I say, it's going to be hard for us to amend, because normally the provisions that allow you to amend are in the trust deed. And so
correct.
You can amend this provision by doing that, or passing this resolution or whatever.
Yeah.
So that's sort of tricky. I mean, I quite often, and now I think, am I just slagging off my own clients? I might be. I get often people say, am I going to win this? Like, I've got this contract and I'm allowed to do X or Y. Am I going to win this case if I do, Z X thing? And I say, may I see the contract, please? And they say, I haven't read it. And I say, well, that's probably the first.
That would be a good starting point.
Yeah. Send me the contract, I will look at it. And it's hard to give you an advice about whether you're going to win your case unless I look at the stuff that we're talking about, So, it's often just that even base level, I think, is a bit of a surprise that you got.
Yeah. But also in those older documents, they were worded differently, and there's also been a lot of legislative changes that have been introduced that then can have an implication. And I know really with a lot of self-managed super fund deeds, if you've got those, then it's very much a requirement that you want to review those every couple of years to ensure that the deed is in alignment to what the legislative changes are, because it is such a long-term asset, potentially, that you do need to make sure. The rules are really specific in a lot of those entity documentation, that if you do something that doesn't allow you to do that, the implications can be very far-reaching. Yeah.
You suddenly lose a tax deduction that's worth millions.
Correct.
Yeah. I've seen that. So if you're a business owner and you're saying, well, I'm not that complicated, and you're listening to this, what do you do differently? Do you go and start a register and say, okay, I'm gonna keep a Dropbox file that's got my unit trust deed, that's got my shareholder agreement, that's got my like my company secretary type documents, or what do you do to simplify it for people like us?
The first thing you would do is come and see us.
With a big check.
Because the reason people would engage in the end is that it's not an area that they're that interested in.
Yeah.
So generally, some people are quite well organised, but the majority are, look, I run a business, I do what I do. Yeah, my accountant sort of dealt with that. Or, someone else has kind of got that. And there's not the awareness that says, okay, if I need to share those documents with people, what's the best way to deal with that? Yeah. So part of it is. It's like, okay, so where is the document? First, you've got to locate it, and then you want to be able to get a soft copy so you can distribute it to multiple people that can kind of assess it and work your way through part of that. Yeah, and it does. I think it is an idea to have a register so where you know where documentation is, you know where the hard copy is. Yeah. And I know a lot of professional services firms are trying not to hold on to original documents. They're actually trying to pass them back to the underlying owners of those trust deeds.
Yeah, I think it's a hard thing. It's a big responsibility these days, especially in the kind of remote world, to have some big file room somewhere that's got all the stuff in it. And then, over years, people move on, people move overseas, people die, things change.
Yep.
You're much better off if you have a soft copy somewhere.
Yeah, so at least, sometimes you've got to have them so the original that's been stamped. But I haven't had many circumstances where someone's not willing to say, well, here's the original, here's a soft copy of the original.
Yeah.
Like that at least is a starting
got
point.
A lot of legs. There's only very rare circumstances where a soft copy, if that's the best you've got, isn't okay. There's still an obsession, especially amongst banks, for wet signatures.
Yep.
Pen on paper, and there's nothing magic about putting a bit of pen on a paper. That's just the same as sending an email with an electronic signature. There's been cases on it, and an electronic signature is perfectly binding. There's nothing.
Because you should be able to trace it back. You've almost got a better audit trail.
You do have a better audit trail. Yeah, it's really just a question of evidence in terms of proving something happened. And a wet signature doesn't prove something happened any more than an email. If you got an email from the person's email, then that's just. Anyone can scribble on a bit of paper. So, there's nothing magic about it, and there's nothing. You don't have to necessarily keep those things for 7 years. There's this kind of perception that once you've, I've written some notes here. I've got some notes in my hand, and I've got to keep them for 7 years, and that's just not right.
Yeah. So, what are some of the other things that you see where people would say to you, "Look, I'm not that complex," but once you start, sort of, I suppose it's like peeling the layers of an onion. As you start to get into it, you then go, well, hang on, but if that is connected to that, then what's the other side of it? Like, there's got to be two parts to everything. It's not just a singular line.
We often get that, I want to do a contract, say, my terms and conditions with my customers, but I just want something really simple, and that's okay. We can do something really simple, right? But the thing is, you go, well, okay, what are we leaving out here? We're going to have payment terms. Do you want, in your terms and conditions, do you want payment terms? You probably do. You want to make sure people pay you. Yeah, and if they don't pay you want to charge them interest. That's a good idea. Yeah. And if they don't pay you and you've got to sue them, do you want them to pay your legal costs? Yeah, you probably do. And if they return goods to you that they've broken, do you want something about that, like that what your returns policy is, what you accept and what you don't, what warranties you take? There's all this, what jurisdiction do you want them to sue you? I think we said it in another podcast. Do you want them to sue you in Morocco or in Melbourne?
Yeah, got to specify. And again, this is where it comes back to. That's why we say, I'm not that complex. Yeah, but the complexity is in your execution component if something goes wrong, not so much if it's not, or the individuals who are named within the entity documentation are no longer here. That's when it starts to get complex.
Yeah. So we can do a one pager, and you do the lawyer thing. You just jam it all into a really small type.
Yeah.
Done. 1 page.
But I can't read it. It's too small. Well, even if you put your glasses on, you're going to do it. Yeah.
Right. Zoom in on your computer.
It's like Willy Wonka and the Chocolate Factory, isn't it? When you're signing down the bottom, you get in
right. So we can certainly do, obviously, shorter contracts are appealing to a lot of customers and whatever, and there's nothing wrong with that, but you do have to leave things out, and that's just a matter of kind of risk management going, well, I'm going to have a shorter document, which is good, but I'm going to have to leave some of the protections out. Then similarly, in terms of the scope of, sometimes people come to us and say, okay, well, I want to buy into this company, can you do the documents to buy in? No problem, can do the documents. But, while you're buying in, you're becoming a minority shareholder, so how about a shareholder agreement if there isn't one already? And that's an additional document. They go, oh, hang on, don't get it complicated. I just want to buy in. And you go, yeah, that's fine. But if you're a minority shareholder and minority owner of the company, you'll have very few rights.
Yes, but also what are you buying?
You're buying the right to vote at a board, but to be outvoted by the main owner. And you're buying a right to dividends, which they may never declare.
Correct.
So, exactly. So maybe a shareholder agreement give you minority rights, which will make your purchase more valuable.
Yes.
So if a shareholder agreement typically sets out what minority shareholders' kind of minimum rights are and what they can and can't do, so everyone's clear, avoid a dispute, and give you some more value in your investment. So then suddenly you've got a share purchase agreement and a shareholder agreement. So you get two documents. So it's not a case of us saying, well, do you want fries with that? Although maybe it is.
There is part of that.
But fries, yeah. But a case of really better protecting the investment. So I guess it ends up being more complicated than perhaps you first thought.
Yes, but at the same time, even though it is a little bit more complicated because you have multiple agreements or documents in place, it also removes an element of complexity because it's very clear, because of those agreements, as to what will and should occur or might occur if something was to go wrong.
Yeah.
How your decision-making process could be.
Yeah, that's absolutely right. Yeah, the reality is, say, if you're a minority shareholder, the law's really vague about, the main shareholder has to act in your best interests. What does that mean? Or act in the best interests of the shareholders as a whole. What does that mean? There's all this vague stuff which can make decision-making very complicated. Because you say, well, I'm the main owner. Can I pay myself a bonus? Is that allowed? Yeah, as long as you're acting in the best interest of the shareholders as a whole. What does that mean? Don't know. So then you have a dispute about it. Whereas the shareholder agreement might say, look, if these things happen, you get a performance bonus, and the performance bonus has to be approved by the board and X, Y, Z. It gives you this process that you can sort of follow that's fair, that's agreed up front, and that takes out complexity, or it takes out uncertainty anyway.
Yes.
Which is very valuable and, as I say, makes your investment more valuable. So why hand over the money unless you got some guarantees about what you're buying,
Yep. But it also, if you're involved with a business and your entities are there, as the business becomes more successful and you grow, and it also then says, well, is there a requirement or a necessity to review the documentation that you own these assets in? And there may be some crossovers that could occur that, again, I think sometimes, yes, it does make things more complex, but it also removes the complexity because you're providing far better clarity around what could or might occur.
Yeah, that's right, certainly. And things change, like legislation changes and
yep.
The rules change around, if you were operating a business that hires out goods, once upon a time you could have a term in your terms and conditions which says that those goods still belong to you, but now unless you register a charge on the Personal Property Securities Register, that those goods don't. And if that company that you hired the goods to goes into liquidation, the liquidator owns them all. So if you're operating a crane hiring business and all these expensive cranes are out on site and the construction company goes on to liquidation, then those cranes are theirs. And unless you update your terms, you don't know about that, and you're taking this massive risk that you don't know you're taking. And again, you sort of think, I don't want to update my terms every 5 minutes, but
but Alex, I'm not that complex.
Yeah, it's not that exactly. I'm just hiring out cranes.
I just run a simple business. I'm not that complex.
Not that complicated.
Yeah.
So there's a level of complexity which is sort of inevitable, and which if you're on top of, then protects you. I mean, we're talking the crane's a real example, right? These cranes are worth like over $1 million a pop.
Yeah.
In fact, there's some mining cranes that we've dealt with that are like 700-ton cranes. That's and if they're on site and it's not like mining companies go under, then that's a huge investment that's at risk because registering the charge costs you about $12.
Yep.
So you probably want to do that. It's a level of complexity that's been introduced by the law. It's not me. I didn't do it.
Yes, and I think that's the other interesting point that you've made is that you may consider your business, not that complex. And it may be set up very, very simply.
Yeah.
However, there is some implied complexity or complexity that's applied to you based upon the legislative changes that are in place.
Yeah.
So your entity, and you may say, yes, I'm not that complex.
Yeah.
You can go, yeah, you're not. However, because of the circumstances or the industry that you function and operate within, makes your business functioning complex.
Yeah.
And there's not always the awareness factor for a lot of people with that.
And really, it's just a matter of getting your documents updated now and again, and making sure that you're, and often say law firms or whatever provide that advice as part of the service if they prepare the documents in the first place. Really just getting the right advisors to give you that kind of regular advice. You don't have to be getting 50 hours of legal advice every month. But getting the right people,
does help.
Well, my clients do. They don't understand what I told them in the first place, so I tell them again. Charge them again. That's part of the business model.
Correct.
Yeah. So yeah. I mean, if we're talking about that I'm not that complicated, I think it's like any project that sometimes things are more complicated than you anticipated when you first got into it because you actually don't know what's involved. And when you're running a business, part of the challenge, and I find this is myself, I've got to be, part lawyer, but also part, IT guy and part, telephone system expert and part, you've got to be able to make decisions on all of these things. So you need the right advisors to help you through that.
Yeah. And you don't always need to be the one that has the intimate knowledge around how to do some of the stuff, but it's identifying who can help you make those decisions. Because sometimes the decision can be, well, look, yes, can your agreements be updated and can you change something else in your organisation? Yes. However, how do we manage the risk? Is it that bad that we need to make an adjustment? Like, is it a major change in legislative or is it a tweaking of the edges? Yeah. And so you may only assess it every couple of years that really, you know what, the risk that I'm willing to take on is insignificant, unless there is a major change in some of the rules that we need to function within.
Yeah, that's
Outside of that, it could only be every 3 to 5 years that you make some of those adjustments.
Yeah, but I mean, often we get ones that haven't been updated in 20 years,
Correct.
And I've got to say that lawyers do tend to, if they look at something, they always think it needs updating.
Of course.
That's not true, right? Yeah, of course they do. Often they're not trying to win work unfairly. They just think, oh, I could do that, and I'd do that differently, because they all sort of think they're cleverer than everyone else. But and I've looked at plenty of documents from clients, and I've said, look, this is okay, this is fine, this will do the trick. Until the law around whatever it is changes, you're okay. As long as it has the right provisions relating to, say, Personal Property Securities Act or whatever it is that is relevant to that particular industry, the Building and Construction Act or whatever. Then it's okay. So you don't need to be updating things all the time, and I wouldn't necessarily be pulling your documents out every 5 minutes, giving them back to your lawyer, especially your new lawyer, because they'll say your old lawyer was shit and they were great. That's the way it is.
But I do think that, is it the PPSR? The personal...
Yes, that's right, the old PPSR. That came out and it was mind-boggling when it happened because it changed the law in that area completely. Yeah,
and I do think that's a one area that a lot of people... sometimes, unless they're a really large organisation, but I think a lot of people not always aware of the implications, like the example that you gave before about, a piece of equipment coming on site and that particular organisation, even though it's only on a rental agreement for the day, if you haven't registered it, that piece of equipment then lands on that site and that business goes into liquidation, gates are shut, no equipment's drawn off, even though it's only a rental agreement.
Yes. Yeah, that's right, which is a surprise. You sort of would think, well, hang on, can't I go and grab that? And it's who has possession of it. And the same thing goes for goods that are delivered but haven't been paid for yet. In the old days, you'd had a provision, you'd say, until you've paid for it, it's still mine and I can go and grab it. They called that a retention of title clause. But now those terms are invalid. If I deliver goods to you and you haven't paid for them, then you've got them. All I've got is a claim to money. You know what I mean?
Yes.
So I can sue you for the money, but if you don't have any money, you've already sold the goods to someone else. I'm stuffed.
Yeah.
So the rules around that have all changed, and it's so simple to fix the issue, and you just register. Just register until you're paid, and it's a simple process, and anyone can do it. You can sign up and do it yourself. You don't need a lawyer. But people don't because they're sort of not aware because it's a new area. But that's the case in the building and construction industry and in the various trades. There's a lot of new legislation comes in that's not well understood.
Yep.
And that does.
Well, that would be like labelling, labelling on food stuff, and any of that sort of labelling requirements would be consistently being assessed and updated. And again, this is where I suppose the mix of. There's two sides to it. One is the ownership of your business. Is that complex? And the answer to that may be no. It's not. the way you're structured is not that complex. The complexity comes into, there's two sides that I look at it. One is what happens if you lose capacity or become deceased. That's where the circumstances in your ownership structure comes, versus the complexity in the operation of your business because of ongoing legislative change that just keeps coming at you.
Yeah, that's right. And people, there are two things that people are sort of usually reluctant to sort of deal with. You know, I've had some people who just will not plan for their own passing away. And you know, the reality is, we're all going to die. It's not a if, it's a when, right? And it's not very nice, but you know, that's the case. It's a when. And you know, having a plan in place for when that happens, and you know, and often that's the most important thing to you, is your legacy, is your children, is you know, the most important, and the thing that you often don't plan for. You know, and you just keep it simple, and then let your children fight over it after you die. Yeah, well, because no one knows when it's going to happen to them. I know people go, "Oh, but I'm fit, I'm healthy." Yeah. Jeepers, the amount of fit and healthy people I know that have just dropped dead on the spot, and for no other reason than if something's happened and they're just. Well, they get, you know, they have an accident or something that just completely out of the blue. Yeah. No pre-existing, no, just for whatever reason. And they're like, oh, yeah, I hadn't thought about that. Yeah, it's just part of your sort of normal business planning, I would have thought. And keeping the complexity at bay. I like your way of putting it that, you know, you're actually keeping things more simple if you can, because you're clarifying where everyone stands.
Well, you have an awareness of the way things are, as opposed to, I haven't read that deed for 15 years and I don't really know where it is. Yeah. I mean, that just gives complexity to everyone, because no one really knows what's going on.
Yeah, and what you then actually often have legally is you have a practice, which is, depending on the context, that can replace whatever the documents say anyway, because you've been doing it this way for 10 years. That becomes everyone's bound by that. But that's not written down anywhere, and, you know, as people come and go, people resign and new people start and all of that stuff, it becomes a bit sort of messy. So you want to kind of cut through that by having a handbook, or having having the rules. I think Seinfeld said that, you know, the lawyer's the guy who's read the inside of the box in the Monopoly game. You know what I mean? It's the only one who's read the rules.
Really?
So you want to. I think as the owner, you should have read the rules, and you should at least know what they are. And if you don't like them, change them. You're the owner.
Correct. Or if you don't understand the rules, obtain some advice that will put it to you in layman's terms, so you do understand it. Because sometimes those legal documents can be very wordy and sometimes difficult to understand. Even when you've read them a lot, sometimes you look at them and go, hang on, what are they actually really trying to say to us there? So either it's then adjusting it, making an amendment to it, or, no, I'm clear around what it says. It's just that it's drafted in such a way that seems more complex than it needs to be.
Yeah, well, that's there. There's a real knack to trying to draft things that make common sense on one hand. I have, obviously, you know, I've got a hand in all of this, and I try and write simply, but you want it to make common sense on one hand, but you also want it to mean exactly what you mean. Exactly. Correct. Because if it ends up being litigated, you know, so they're sometimes hard to do, because generally when we speak, we oversimplify things, and so the legal writing can be difficult to understand. But if you don't understand, you know, read it again, or ask someone, you know, find out. I think I'm really flabbergasted sometimes how often I get asked to advise on documents that people haven't read, or I prepare documents that people say they're fine because they trust me, but I'm like, just read them. Like, you got to read them. You know, it's a 5-minute job.
Yeah, but I don't understand it. I know, that's why you read you need to be reading them, and if you don't understand,
have read them.
Yeah, it's a classic. Oh no, I haven't read that one, but you signed it. Yeah, I know, but no, they just. Yeah, no. Okay.
Yeah, well, everyone
any of those sorts of documents, otherwise, you know. And again, that's probably just you and I. We would read them. So, are there anything that, I mean, I suppose my view, and to kind of wrap this one up, Alex, is really, I know people's view of their own affairs is always that they're not complex, but getting clarity for yourself by either knowing where your documentation is, and just reviewing it, whether it be directly yourself or through one of your advisor base, just to make sure there is clarity around what you're doing. That's how I kind of look at it from that point of view. Anything else you want to add to that?
Yeah, I mean, I'd agree with that. I think every project you ever do is longer and more complex than you want it to be, and often that's because you don't really know what's involved. So I think find out, get some awareness, and then make things as clear as you can be, and well documented as you can, so that you're well prepared for the future. I mean that's just part of his sensible business planning, to focus on getting clarity around what matters and having that well documented into the future.
Yeah. Yep. I agree. And as we sort of said before, even though you may not be complex, or you think that you're not complex, by having things in place, and it gives you a bit of clarity, which makes things less complex, even though they can be complex. If that makes sense. I just think if you've got it recovered,
it's not complex.
I feel as though I feel like a dog chasing its tail on that one. But that's just the way it goes. All right. Well, thank you, Alex. As always, an absolute pleasure. And I do think we will catch people up on the next episode, when that might be.
All right. Thanks, Dave. Thanks, everyone. Cheers.
Beauty. Thanks, Alex.